Case 79, Taylor v. Huerta. We find ourselves in the U.S. Court of Appeals for the D.C. Circuit. Facts. Congress has charged the FAA with maintaining the safety of the nation's air traffic. As small unmanned aircraft, or drones, have become more popular, the number of unmanned aircraft-related safety incidents has increased. In 2015, to address that trend, the FAA promulgated a rule known as the Registration Rule. That rule requires the owners of small unmanned aircraft operated for recreational purposes to register with the FAA. Unmanned aircraft operated for recreational purposes are known as model aircraft, and we will use that term throughout. Separately, the FAA published a notice known as Advisory Circular 9157A, announcing that model aircraft would be subject to certain flight restrictions in the Washington, D.C. area. Petitioner John Taylor is a model aircraft hobbyist who is now required to register with the FAA. He has operated model aircraft from his home in the Washington, D.C. area, and he wants to continue to do so without registering or complying with the new flight restrictions. Taylor filed petitions in this court to challenge the FAA's registration rule and the advisory circular. So what's the issue? Whether the FAA's registration rule violates Section 336 of the FAA Modernization Reform Act, and whether Taylor's permission for review of Advisory Circular 9157A is timely. The court held that the FAA's registration rule violates Section 336 of the FAA Modernization and Reform Act. They vacated the registration rule to the extent it applies to model aircraft. Because Taylor's petition for review of Advisory Circular 9157A was untimely, that petition is denied. Let's look at some reasoning. To begin, Taylor did not think that the FAA had the statutory authority to issue the registration rule and require him to register. Taylor was right. In 2012, Congress passed and President Obama signed the FAA Modernization and Reform Act. Section 336 of that act states that the FAA may not promulgate any rule or regulation regarding a model aircraft. The FAA's 2015 registration rule, which applies to model aircraft, directly violates that clear statutory prohibition. The court therefore granted Taylor's petition and vacated the registration rule to the extent it applies to model aircraft. Taylor challenged Advisory Circular 9157A on the ground that the circular likewise violated Section 336. That circular prohibits the operation of model aircraft in various restricted areas, including the flight-restricted zone around Washington, D.C. But Taylor's petition challenging the advisory circular was untimely. By statute, a petitioner must challenge an FAA order within 60 days of the order's issuance unless there are reasonable grounds for delay. Taylor acknowledged that he filed his petition challenging the advisory circular outside the 60-day window. He did not have reasonable grounds for the late filing. His petition for review of AC 9157A was therefore denied. Note that the registration rule is still a requirement after this decision, but not because the FAA went back to the drawing board and proposed a new registration rule. Rather, it was reinstated as part of the National Defense Reauthorization Act signed by President Trump in 2017.